Hi, my name is Adam Tomasi. I did LD for 5 years, and I'm now a policy debater at Wake Forest University. And I'm here to provide the topic analysis for champion briefs on the jury nullification topic. So the core controversy of this topic is summarized by two competing ideas. The first, for the affirmative, is that an unjust law is no law at all. Sorry, I have a cold. Because what jury nullification is a juror or a group of jurors voting not guilty, not because of some factual question of the defendant being not guilty, but rather because they believe that the law in question should not exist in the first place. On the negative, you have the argument that there needs to be some stable and consistent rule of law, and that jury nullification makes the execution of the law too subjective. No matter what affirmative or negative position you'll find, all of these positions kind of rely on those two core assumptions which make the topic so controversial among judges, legal scholars, and so on. So now we'll get into the kind of core debate by addressing the text of the resolution. Sorry. So, resolved. In the United States criminal justice system, jury nullification ought to be used in the face of perceived injustice. So, United States criminal justice system probably means that the affirmative has to defend that the federal government do something to encourage jury nullification, because the issue is not that jurors are incapable of nullifying. They have the power to nullify, but judges don't often like to tell jurors or inform them that they have the power to nullify, and oftentimes defendants are prohibited from making their defense centered around informing juries that they have the power to nullify. The affirmative would entail that the United States federal government maybe require judges inform juries more about this, or that they permit defendants to be able to do something about this. The affirmative might even not take that sort of policy route and argue that they're just speaking about the individual moral obligations of jurors rather than a larger statement of policy. But if the affirmative were to defend some statement of policy, they probably have to defend that the federal government of the United States do something about the criminal justice system. You could argue that all 50 states should do something, and that United States criminal justice system is a question of state courts. That's a little harder to defend theoretically, mainly because it's kind of utopian to have all 50 states do something in concert. Whereas it's more realistic for the federal government to be stepping in. That's not to say you can't read a states-based affirmative, but you inevitably have to have the theory. So to continue, jury nullification, again, it's when a juror votes not guilty based on conscience rather than on a factual question of were they guilty or not guilty. Ought is indicating moral obligation. In the face of, that's an interesting phrase. It was part of the NSCA Nationals topic last year, where the topic was inaction in the face of injustice makes individuals morally culpable. Affirmatives would say that in the face of means the injustice is imminent, to get out of negative arguments about how there would be some infinite obligation to deal with injustices. I don't think this topicality debate will hopefully become that relevant, simply because the injustice of a defendant being sentenced for a law that should not exist in the first place is imminent to the jurors. I mean, I hope that people just debate jury nullification instead of engaging in some sort of convoluted tea debate. But anyways, to continue, perceived injustice, this means that the affirmative would have to defend that jurors have a right to nullify based on what they think is an unjust law, whether they are correct in thinking that that is an unjust law or not. Although a lot of affirmatives are going to be about things that, like, uncontroversially are injustices, like structural racism, and that perceived injustice is just a matter of, like, recognizing the obviousness of, like, some laws just not, deserving to exist on the books. The first affirmative I'll talk about, is that of ethical pluralism. This is based in the philosophy of W.D. Ross, arguing that rather than looking to some comprehensive ethical theory where there's a single foundational principle that we apply to every single circumstance or moral dilemma, like where utilitarianism says, no matter what, maximize utility, Kantianism says, no matter what, follow the categorical imperative, pluralism says, no, morality in the real world is not quite like that. Our duties are contextual to our varying personal relationships. We have a plurality of duties, and we assess the stringency of these duties through our intuition, where we intuit, based upon the context of each of our varying personal relationships, what our duties ought to be. And the thesis of this affirmative is that we have a duty to avoid causing unjust harm to others. Jury nullification is essential for jurors to avoid causing unjust harm to defendants, for whom they would be potentially sentencing to harsh and unpleasant conditions for something that people should not be incarcerated for in the first place, and that while we do have a duty to uphold the rule of law, that our duty to uphold the rule of law is not as stringent in this particular context. Pluralists emphasize that contextual nature of our duties because they believe that we need to focus on prima facie duties, duties that generally matter and ought to be prioritized but become less stringent based upon particular circumstances versus absolute duties that are stringent no matter what we do in every single circumstance. There are two reasons why I like this affirmative. First is that it enables you to co-opt a lot of the framework debate. Negative says, ethical obligation to follow the rule of law. Affirmative says, yeah, that's true, but at best it's only a prima facie duty, so you prefer my framework. Second is the evidence that supports the aft contention here is really grounded in the core of the topic literature. One article you should look at is The Duty to Disregard the Law by Michael Huemer, Huemer, where he uses that rhetoric of prima facie duty to make this exact affirmative argument that I just outlined the thesis of. And I'm virtually certain that the Huemer article effectively rebuts virtually every stock negative argument, making this article really effective. Another article you should look at is one by Aaron McKnight, that's like knight as in shining armor, called Jury Nullification as a Tool to Balance the Demands of Law and Justice. So the second affirmative I want to talk about from a more critical lens where you're challenging oppression or structural violence is an affirmative based in legal realism. Legal realism is the view that there is no objective or consistent body of rules or laws that govern the entirety of our society, that the very idea of a rule of law is a myth, and our belief in some kind of objective rule of law just props up oppressive power structures. The main article you want to look to for this is The Myth of the Rule of Law by John Hasnas, Hasnas, and he outlines this argument very, very effectively. And your contention is that jury nullification is opposed to this idea of some stable and objective body of rules that we can apply to every single circumstance. Jury nullification is all about subjectivity and about understanding the particulars of each case, and that, yes, juries are acting politically, but the law is irreducibly political, which means that any of the harms the negative might isolate with jury nullification are inevitable, but the affirmative has comparatively better offense because it's better to be realistic and recognize that the rule of law is a myth. You may ask, well, what if the negative doesn't read a rule of law and see? It doesn't matter because your contention level is that jury nullification subverts this idea of an objective rule of law, which means that you still have offense. The third affirmative I think that you should consider is a utilitarian affirmative that talks about how encouraging jury nullification makes eventual legalization of marijuana inevitable. There are lots of activists like Tony Newman in Jury Nullification, an important tool against drug war injustices, who argue that jury nullification provides the kind of bottom-up pressure that eventually leads to national legalization of marijuana, just as jury nullification was credited with the end of prohibition of alcohol because more and more juries refused to enforce the law, made prosecutors look silly when they brought cases about alcohol in the trial, and made legislators question the utility of these laws. You would argue, in turn, that legalization of marijuana leads to some significant utilitarian benefit, like it substantially weakens drug cartels, which are causing lots of instability in Mexico, or maybe that it alleviates California's drought, which has substantial environmental consequences. There are lots of arguments as to why legalization of marijuana would be good from a utilitarian standpoint. There are also lots of arguments for why legalization would be bad from a utilitarian standpoint that I think the negatives should take advantage of if they're to debate this affirmative, and that the affirmative certainly needs to be prepared for if they want to read this affirmative. The reason why I think it's an effective affirmative is because, first, is that it gives you mileage against critical arguments on the negative, where you can say that legalization of marijuana is beneficial to minority communities who are disproportionately policed and sentenced. And second is I think that if you're like really, really well prepped on the impact level, that even if negatives go for legalization of marijuana is bad, that you'll be prepared enough where you will efficiently and effectively win these debates. Um, Before I talk about the fourth and final affirmative I wanted to talk about, I quickly wanted to get back to legal realism and talk about why I think that would be an effective affirmative, something I forgot to mention. Two reasons. First is it is directly an answer to the most common NC on the topic. It's essentially an impact term to that entire NC. And second is something effective about this affirmative against critical positions on the negative is that those positions are just like jury nullification has been historically oppressive in XYZ ways. But your argument would be yes, all of that might be true, but the negative's conclusion, at least implicitly, is that jury nullification is therefore bad because it is a diversion from an objective rule of law. Where it's like juries are acting too subjectively, we need to reject jury nullification and instead embrace like the actually existing rule of law, right, that challenges these injustices, right? But that ignores that the rule of law is irreducibly subjective. And you could say that belief in the rule of law is what makes all of the oppression they talk about inevitable, which means only the affirmative can solve. The permutation's best because we can acknowledge that jury nullification has had some deficiencies, but that doesn't deny that it can be justified if people do it for the right reasons. So fourth and final affirmative position I want to talk about is the Constitution affirmative. There's an article that you should look into by Duane that's called Jury Nullification, the Top Secret Constitutional Right. And this talks about how the historical roots of our Sixth Amendment right to a trial by jury is that the purpose of that amendment is to check back against government tyranny. And you could argue that jury nullification is essential to the kind of checks and balances of our constitutional system. Because it ensures that an unaccountable government can't hold us to laws that violate our individual rights and freedoms as codified in the Constitution. I think this affirmative is particularly effective, first because it's a legal topic, so the constitutional literature is pretty good, and second because I have yet to see a negative article that says jury nullification is unconstitutional, which means that even though this affirmative can be turned, it's going to be pretty difficult for the negative to do that, which means you'll have a lot of mileage on the contention level. So now we'll go to negative arguments, but before I do that, I want to note that there's a really awesome article by Teresa Conaway, Conaway, called Jury Nullification, a Selective Annotated Bibliography, where it lists a ton of articles about the topic, and it gives the gist of each of the articles with the citation. So it summarizes the articles, and you can assess whether they're useful before you go on to read them, which is the purpose of an annotated bibliography. So that'll be really helpful with your research. So to talk about negative positions. First is the rule of law NC, where you'd argue that we have a moral obligation, especially jurors do, to faithfully execute all of the laws that are on the books, and that jury nullification is inconsistent with this because it infuses subjectivity into law, which undermines kind of like a codified set of laws, where you could have two individuals that commit the same crime, and one of them gets sentenced to jail because the jury happened to choose to decide based upon a factual question of guilt, and then you have one person who was, they committed the same crime, but they get let off because the jury that they happened to have was a jury that chose to nullify, which means that the law would create, contradictory outcomes, and that's problematic. Or at least in its execution, contradictory outcomes would result. And your argument would be that that's problematic. One argument that you need to consider if you're going to read this negative case is that an unjust law is no law at all. Your response to that should be that even if that's true, that it's better for people who serve on juries to pursue political activism outside of a courtroom to rectify those injustices rather than undermining what should be the fundamental obligation of a jury to only decide a factual question of guilt. Second is that you can say that a more subjective legal system leads to injustices in the long term, like how white Southern juries would nullify in favor of defendants that committed hate crimes during the Jim Crow era, and also how reverse jury nullification might result, where you'll have juries who vote guilty even when someone was factually not guilty, simply because they don't like the person who's the defendant. Like, they might be like, oh, this person's kind of rough looking. they probably didn't do anything, but I don't want them walking around my streets, right? So, you could have people that act, very, very arbitrarily. You could say that the affirmative fails to achieve the justice that they say is a prerequisite to the rule of law. Alternatively, you could make the argument that Socrates did in the Crito, where he says that people have a moral obligation to follow all of the laws of a state. So I think that's where you should get most of your framework. Where Socrates was sentenced to death for quote unquote corrupting the youth, and when he was in jail, one of his friends visited him and asked, why don't you escape? And Socrates said, well, I feel I have an obligation to respect all of the official laws of the city-state to which I belong. I'm really sorry about this cough. But anyway, to continue, there's a variation on this negative case, the democracy NC, where you could say that juries would be acting in a way that is democratically unaccountable because a group of 12 is subverting a law that had been officially sanctioned by a democratically elected legislature. That it only takes one juror for someone to end up being ruled not guilty, because juries have to rule unanimously on guilt, and that means it would take one person to subvert a majority rule within a democracy, and in a democracy we don't invest that much power in a single person, which means that jury nullification is undemocratic. This is similar to the rule of law in C in that it says you got to follow all the laws in the books, but it provides an interesting spin on that, which I think makes the rule of law argument a lot more effective. I also think that this could be effectively paired with a counter plan, where you argue that instead of encouraging jury nullification, we should encourage prosecutorial discretion. Prosecutorial discretion is where the prosecutor would be essentially nullifying, where they'd refuse to bring a case to trial out of moral conscience. So it solves the entirety of the affirmative, because it achieves the same effect of jury nullification, but invests that in the prosecutor instead of juries. And there's an article by Oren Kerr, Kerr, called The Problem with Jury Nullification, where he argues that prosecutorial discretion is better than jury nullification, because prosecutors are democratically accountable, whereas juries are not. Which means the NC is a net benefit to the counterclaim. And this also enables you to effectively defend the NC in a way that gets out of the best argument against it. That what happens when democracies make really immoral decisions? You could be like, I know, right? But that's why the counterclaim is good, because prosecutors will nullify in instances where there's like an obvious injustice, checking back against some of the worst decisions that a democracy might make. On the question of competition, that counterplan probably honestly only competes with net benefits, simply because theoretically speaking, we could have both heightened prosecutorial discretion and more jury nullification. But there are some apt authors, like I think the name is Glenn Harlan Reynolds, who argue that jury nullification would weaken the power of prosecutors. So you could say that there's a direct zero-sum trade-off, where the more we invest in, the more we encourage jury nullification, the more that weakens the role and influence of prosecutors, which means it would be illogical to do both. The last negative position that I want to talk about is that jury nullification is oppressive in some way. For example, this would be a critique about how jury nullification is super racist because it's historically been used in racist ways, and that the affirmative's assumption that jury nullification results in just decisions is an ahistorical and fundamentally flawed notion. I think this is a particularly effective negative strategy because a lot of affirmatives are going to assume that jury nullification results in just decisions. They're just going to be like, justice matters more than the rule of law. Gotta respond to injustices. That's important. But if you win that jury nullification leads to more of the injustice they criticize, then that would mean jury nullification ought not happen. They may say, well, my affirmative is not consequentialist, so I don't have to win that solvency portion. But even if their affirmative is not consequentialist, that just means that their affirmative does not believe that the consequences of an action are the only things that matter to morality. But what does matter to morality under their framework has to be, logically, that the injustices they claim are bad for whatever reason are actually dealt with. Because these injustices should not continue. The affirmative has to agree with that. And if jury nullification is counterproductive for achieving the aims they do want to achieve, it seems like they do have to win that essential solvency question. So to close, this is kind of a synopsis of some of the common affirmative and negative positions on the topic. It's a floor, not a ceiling. Gives you a general overview of what the topic's going to look like, but you should take it in any direction you want, or in any direction the topic takes you, because bottom-up research is the best way to go. Again, I'm Adam Tomasi, on behalf of Champion Briefs. I was happy to provide this topic analysis. If you have any questions at all about either the topic itself or what I covered in this topic analysis, you can email me at tomasidebate@gmail.com. Thank you, and I hope you have some awesome debates on jury nullification.